John Doe, case number 1211 versus Sex Offender Registry Board.
Mr. Ness?
Kaplan, Steve Kaplan. Steve Kaplan.
Mr. Kaplan, are you going first? Yes. That's
I'm Stephen Kaplan of Northampton, Massachusetts, and I'm glad to be here once again after some years. This is a case involving a former offender who made as good a showing as anybody is likely to see that he was totally rehabilitated. The hearing examiner of the Sex Offender Registry Board recited many factors in which he made findings that were favorable to the former offender. I say former offender because, as Mr. Onek pointed out in the amicus brief, a dozen years had gone by since he had committed what I say is a single predicate offense. There may be a little bit of difference between myself and my brother on that issue. In any event, I'm not going to recite all of the factors of rehabilitation. They're there. If the court wants to ask me any questions about that, I will answer them.
Let me ask you this. Why can't the legislature conclude that someone who has been twice convicted of a sex offense against a child should be subject to registration for life? Why isn't that an appropriate determination?
Not at all. I would say that I would take the position under Doe number 3 and Doe number 5 that the individual has a right to a hearing at which, an individualized hearing at which he has the opportunity to show that he in particular does not present that kind of danger to vulnerable populations. As to the number of convictions, we can get into that later if the court doesn't choose to largely allow me to rest on what I said in the reply brief on that issue.
Well, it strikes me that an individualized hearing, of course, was held here to determine what classification he would be in. And the registration requirements are hardly onerous. Certainly not as onerous as being classified as a level 2 or a level 3 offender. He was classified as a level 1, low risk of reoffense. Is that right?
That's right, Your Honor.
So all he has to do is send in a registration form to the board every year indicating where he's living.
Not really. I think that when the court was addressing the similar problem in Doe number 3, that they pointed out that even to be denominated as a sex offender at all was to to subject the defendant, the plaintiff, the individual, to the statutory branding of him as a public danger. Since that time, obviously, there has been a certain interior fluidity within the court as to what constitutes the statutory branding. Justice Greeney, in particular, who was part of the court of Doe number 3, afterwards wrote, he joined the plurality in Doe number 5, in which the court took the position that perhaps the branding really didn't amount to much in the case of a level 1 offender. I believe that's my recollection. But be that as it may, it obviously means a great deal. I would refer the court to Justice Holmes when he said that a page of history is worth a volume of logic. and that the,
Well, let's think about this branding. Under the current statute, there is no dissemination of this information to the public if you're a level 1 classified sex offender. Isn't that right?
that may be right today. That may be right today. The Congress of the United States has passed the Adam Walsh Act, and under the Adam Walsh Act, an offender against a child under age 12 is going to be subject to Internet dissemination of his registry information if the state chooses to participate and chooses not to forego I believe my brother in his brief said it's about $1 million a year. Here's the state which is suffering under the big dig. We can't afford to give away $1 million a year. We can't afford to give away $100,000 a year. And the state is going to forfeit this federal grant money unless it makes the registration information of former offenders against children age under 12 available for dissemination on the
So the
Internet.
statute would have to be amended to permit that, right? The state statute would have to be amended?
I don't know that for a fact. I don't know that at all. I mean, we have various, on the contrary, I mean, the state statute as it stands is the statute that I'm attacking here. However, the state statute says you have tiers 1, 2, and 3, levels 1, 2, and 3. The man is put in a level 1. He's not put in a level 3. The state statute relative to Internet dissemination is directed to level 3, is not directed to level 1.
Can you, accepting for a moment the validity of the notion that once someone gets classified, whether they be 1, 2, or 3, there is a social stigma of some consequence that attaches to that. What precisely is the legal problem in your mind with what occurred here? What's wrong with the statute? What's wrong with the way it was administered and applied? What's your beef?
Okay. We asked the hearing examiner to give the man a level 0.
Why not?
And, excuse me?
Well, okay, go ahead.
And the hearing examiner, in his decision, said, I'm precluded from doing so. 278K D2.
Well, is your basic argument that the statute as applied here to your client produced such an irrational result that makes the whole process invalid? Is that your basic argument?
My basis of argument is that under Article 12 of the Declaration of Rights that he's being deprived of a major liberty interest. He's being deprived, he's being subjected to emotional injury. I know that the court...
But we've said that the process is all right.
Excuse me, please?
Haven't we said in past cases that the process in general, the statute as it's set forth, is all right?
Not at all. The court has constantly paired the statute, looked at certain aspects, upheld some aspects, struck down others, left others to be decided another day on facts.
What specifically wrong happened here?
What happened here is that notwithstanding a hugely powerful factual showing of rehabilitation, that A, he has to go on registering very likely for the rest of his life, and B, that he's put in danger that at any moment the state is going to climb aboard the Adam Walsh Act and is going to make his registry information available for dissemination on the Internet.
And that occurred because of what legal error?
The legal error was the legal error by the hearing examiner, affirmed by the Superior Court judge, of allowing the man a meaningful hearing on the question of whether he personally presented a danger of harm to vulnerable populations.
Such that he would have to register at all. I take it your complaint is he deserved an opportunity to demonstrate that he needn't register at all.
Thank you, Your Honor. That's
And
right.
here he didn't get that because the hearing examiner ruled that he was covered by a provision which excluded him from that form of
Yes, sir.
relief.
That's right.
So I take it in common parlance, would it be fair to conclude, Mr. Kaplan, that it was not that somebody misapplied the statute, leaving aside the one or two offenses, but that as applied to your client, the statute deprived him of due process rights?
That's right.
Thank you.
As to that, I
And that is because the legislature, as Justice Cordy said, has enacted a statute that says if one is convicted of 2 acts against a child, that defendant must be required to register no matter what the evidence of rehabilitation.
That's right. And in addition to that, the legislature says if he has committed a sexually violent offense, and a sexually violent offense essentially has the same definition as an offense against a child, he has to register for a very lengthy period of time.
How do you deal with the language in Doe number 5 that says, with respect to regulations, never mind a statute, that the regulations may treat certain offenders, for example, those convicted of repeated crimes of violence against young children, as automatically presenting a threat to vulnerable populations?
Well, of course, the short answer is that in Doe number 5, the court nevertheless required an individualized hearing in the case of somebody whose offense was against a child, among other reasons, because the SORB never actually never actually enacted a regulation in that particular language. My secondary argument is that when this court was deciding Doe number 3, that at that time, when the court said acts of violence, they meant acts of violence where, in the ordinary sense, it was only afterwards that the legislature chose to define an ordinary or an indecent act against a child of sufficient youth as being violent. We would take the position that this particular dictum by the court, which was never actually fulfilled in the form of a regulation, was referring to acts of violence in the ordinary dictionary sense, and that it didn't really go further than that. I also made the argument, which the Superior Court judge rejected, which was that the binding opinion in Doe number 5 was the central opinion by the concurring Justice Cowan, and I have cited certain authority to that that would lead to that result. I cited a couple of Supreme Court of the United States cases on that issue, because that was actually the middle decision, and Justice Cowan's vote could be added to that of the dissenting justices who, as I look at the bench, are to my right. And but in any event, I particularly relied on what Justice Cowan said, which was, if I can ever find it now, I'm sorry, was that Roe? Might have been Roe. It might, I guess it was Roe, excuse me. In any event, it left open an attack on a particular statute as applied. And for that reason, we would take the position that this was the actual central decision, and this was the actual opinion of the court in Roe. And I think that Justice Cowen's concurring opinion reaffirmed the importance and the right of the individual to a particular individualized hearing in order to determine the actual danger that was presented. Throughout all of this, we have taken the position that the basic moral imperative of these cases is set out in Judge Freed's concurring opinion in Doe number 3, which contains some very trenchant and eloquent language to which we recur and which we ask the court to accept.
Thank you, Mr. Kaplan. Mr. Less?
Thank you. Madam Chief Justice, and may it please the Court. Good morning. My name is Daniel Less. I'm a Special Assistant Attorney General representing the Sex Offender Registry Board in this matter. Your Honors need not reach the constitutional issue raised in plaintiff's brief in this case, as there was substantial evidence to support, as the Superior Court so found, the hearing examiner's decision to classify plaintiff as a Level 1 sex offender.
But can we discuss it anyway?
Sure.
Well, we can discuss it, and you can certainly answer Justice Cordy's question. But I want to know, what the evidence is that of the continuing risk to vulnerable populations. In other words, I'm not going to get into whether there were one or two offenses, but what was the evidence that he is now a continuing risk, which may indirectly answer Justice Cordy's question?
Well, certainly, it's the nature of his offending behavior is certainly an important factor to
if you're
consider.
going to tell me that anybody who attempts anal intercourse with a child under the age of 10 can never be rehabilitated, that's one thing. But what I want to know is what the hearing officer.
Well, okay.
Sure.
Well, one thing that I think was particularly significant in this case was the testimony of his own therapist in this case, who came in and testified on his own behalf, and testified quite eloquently as to the rehabilitative efforts that plaintiff engaged in, and that the hearing examiner credited in fact, reducing him from a recommendation of a Level 2 to a Level 1. But the expert in both his reports and his testimony said that he can never, that he's as close to nil as you can get, or that the risk was negligible. And that, in essence, is what low risk is, that is, it's not zero, it is low. Low is a range. In the common meaning of the term low,
Could you give an example of somebody who would present no risk to reoffend?
Sure, and the board has found at least 400 offenders who represent no risk of reoffending. These would be cases where the court had indicated, for example, in Doe 5, where sexual experimentation, where you have juvenile offenders who are, because the parents are upset or there's a prosecution, they are convicted of statutory rape. The board has routinely...
Does it apply, have there been any, or can you give me any other examples other than juveniles engaging in what would be consensual acts, except for the statute?
Open and gross cases, cases that involve some of the pornography-type cases, certain indecent assault and battery cases that where an offender, where the case is over 14, where based on either rehabilitative efforts or stability in the community, the offender comes to a zero, represents no risk, and the board has so found and has so relieved those offenders.
Mr. Less, would you agree with me, and you need not, that where you have what I would call adult, I don't know how old was the defendant at the time of the...
At the time, he was 44.
So, I mean, adult.
Yes.
We're not talking about a 16, 15, 14. And young, very young child.
Mm-hmm.
So this is not 14-year-old who might have looked as if she was 17. We're talking about a very young child. It is hard for me to imagine that there would be any therapist, even if after extensive rehabilitative and even if no evidence of any subsequent act, could or would testify that there is zero risk.
I think that that's fair to say, and I think that that's why the legislature came to the conclusion that offenders who engage in that type of behavior are always going to represent that type
Then
of risk.
how do you deal with the language in Doe against 5 that says it is permissible for the state to say that certain people are automatically classified as being required to register, provided that they have the opportunity to present evidence that they pose a grave threat to children and other vulnerable populations, and that the risk of reoffense in those circumstances is compelling. In other words, what I'm trying to work out here is, let us, Justice Cowan in Roe drew a distinction between legislation and dissemination.
Sure.
For purposes of discussion, let us assume, not unreasonably, that there will be dissemination if the Commonwealth decides to participate in, perfectly reasonably, with the federal statute, not only, by the way, for monetary reasons, that there will be dissemination. And let us assume that both the fact of legislation and, more particularly, dissemination has a significant impact on an individual's liberty interests. That essentially what you do is, if the Commonwealth has set the barrier, so low that you and I are practically in agreement that where the sex offender has perpetrated the kinds of acts that you and I have just laid out, this case would always be classified as a level 1.
Level 1. Well, there's a lot to extract out of that. I think, first of all, it's very difficult to extract out, particularly when you look at Doe 5, that in the context of Doe 5, where there was public dissemination going on from the outset before there was any opportunity for any classification, and that was a significant impairment on the implicated liberty interest that the court found.
That's why I link it into the dissemination, which we don't have yet. But
Yeah,
it's there.
and that's why, in the context that the board looked at this case, and the court, the hearing examiner looked at this case and indicated that in this case, public dissemination wasn't necessary because he represented a
No, but it's going to
risk.
happen. The board is going to. Again, there's going to be a problem, because you're going to have all kinds of ex post facto things which are not going to stand up, and there's going to be dissemination.
Well, I think it's premature to come to that conclusion in terms of what the Adam Walsh Act is going to be, because in part of the Adam Walsh Act is there's a section in it, I believe it's Section 125, that does permit
Let me put it this way. I'm sorry, that does permit.
Well, it permits
It has an
courts.
opt-out.
It permits states to opt out of certain provisions if they would conflict with state constitutional claims. So it's very. I think it's premature to
Let
come.
me put it this way. If I'm looking at the rationality of the statute,
Okay.
and if the legislature has determined, perhaps by having hearings of people who've dealt with this kind of situation, that there can never be no risk of reoffense, it would seem to me that having the police, the state, know where you live is not as important as having people in your community know where you live, because that's the whole point
Right.
when you think that there is a risk of reoffense. I mean, it's quite helpful to have the state know where you live, because if you do something, the state will know where to find you. But there's nothing to suggest that this particular person has tried to evade.
Correct.
And so it seems to me that we really have to confront at what point in our society we say, even though whatever it was, negligible or is lower range, or the chance of reoffense is about as low as you can go, we nevertheless think that,
Well,
community
there's two
should be
there's two
informed.
things I have to say to that. I suggest one area that the court could look at is the language in Coe versus SORB, which talked about the Internet and publishing level 3 offenders on the Internet. And the court indicated that, at least for level 3 offenders, they saw an apt fit in terms of that. And then that, I think, is a question that this court would have to make a determination as to whether an offender who's been deemed a low risk to reoffend represents an apt, Internet dissemination represents an apt fit. And it may or it may not. I would say this, though. If we've said that he's a low risk, that if that was something that was published, it's certainly something that the police know. So in terms of a branding as a public danger, he's not really being branded as a public danger. We're not branding him as a high risk. We're saying this is a low risk, and the police certainly know that. And quite possibly, if that information...
If you're having anything to do with children,
Mm-hmm.
Teaching, a computer operator who comes into service,
Mm-hmm.
the elementary school, whatever it is, surely you're going to take that into account. In other words, the impact on somebody's livelihood is significant.
Absolutely. As in fact, the evidence in this case was about this plaintiff, as his wife testified in this case, that in the religious center where he works, is that the religious center knows about his situation, and they make sure, and she makes sure that he's not involved in conduct with children where he is alone with them. And when his daughter, his biological daughter, comes to visit them, they do the same thing. And there's with that such reasoned and well rational behavior that people of good intentions can do, that may work just as well in the community as well. If you're not putting everybody out as other states do, where everybody's just lumped together as sex offender and everybody's on the Internet with no determination as to what their risk level is. If you were to indicate that he's a low, moderate, or high, you're providing people with more information who can make the proper determination. It might be a situation where he shouldn't be at that employment place at all, or maybe it's something that with reasonable accommodations he can work with. But that's a situation that...
Mr. Less, excuse me for interrupting you.
Sure.
Would it be fair to say that your argument essentially boils down to this, and correct me if I'm wrong. First, you don't have to reach the constitutional question because there's plenty of evidence here. Second,
Correct.
to the extent that you do reach the constitutional question, and this is an as-applied challenge, in this particular case, the as-applied challenge fails because when you have adult, and I don't know how we're going to define adult, but at least in this case a 44-year-old and child, very young child, and a form of a sexual assault which is violent, it was reasonable for the Commonwealth to require, for the state to say there should be classification, there must be classification as a level 1 offender.
I think it even goes maybe just a tad further than as applied, because I think if you're looking at this from what plaintiff really complains about here is the language in the statute that says he can't be classified below a level 1, and he will have to be a level 1 for life, and that is essentially he's making a procedural due process challenge on that, which in many other contexts this court has said you got your due process with the legislative classification process, and that it's really a substantive due process challenge, and it's a rational. I would suggest that it's a rational. It serves a rational purpose for a legitimate
Well, it
conclusion.
might in these circumstances, but it might not, as Justice Cowen suggests, if it's, 2 convictions of statutory rape of, of
But the statute
14-year-olds.
takes care of that because it allows the board to relieve those offenders, because if they're juvenile offenders and they're not convicted, the statute doesn't say convicted, it says adjudicated, and it leaves out the word adjudicated when you're talking about the lifetime provision. So we have the ability and do that. So it narrows, it takes that concern out of Doe 5 of that statute, the 96 statute, casts such a wide net. The legislature narrowed that to the very focus of the type of offender that we're talking about here. And this offender's case represents the reasonableness and the rationalness behind the legislature's decision to require sex offenders who, even though they do everything that they could possibly do to rehabilitate themselves, that they are going to continue to represent some degree of risk and never reach the point of zero. And that's a rational, reasonable conclusion that the legislature did, narrowly tailored to the classification level and the classification distinctions that the board has to make.
Can I ask you some questions about the statute?
Sure.
178K2D. I've had a little trouble working it out. Explain to me who will always have to register under this statute.
If you are convicted of a sexually violent offense, and those are enumerated in 178C, and if you have been convicted of 2 or more, I'm going to shorthand phrase Wetterling offenses.
Well, that's my problem.
Okay.
It says two or more sex offenses defined as sex offenses pursuant to the Wetterling Act. Well, the Wetterling Act doesn't define sex offenses.
The board does in its regulations.
Excuse me?
In the board's regulations, under 178.
I'm reading the statute now. The statute says 2 or more sex offenses as defined
Under the Wetterling.
under the Wetterling Act. And Wetterling Act doesn't define sex offenses.
Well, the Wetterling Act, there is a provision cited in my brief as to what they define as a sex offense. The Wetterling Act, I think, does define what sex offense is.
No, it doesn't. It defines a lot of things, but not that. Crimes against minors, sexual predators, sexual violent offenses, but not sexual offenses.
Well, using the board's authority, the board has the authority under the statute to designate what under that would constitute lifetime registration. The board has defined in its regulations, under the definition section in the board's regulations, what are the Wetterling offenses under.
Where is that section?
That would be, that's section, I see I've exceeded my time. If I can just answer Justice Cordy's question.
Please.
Thank you. It's section 1.03, and it is the last definition that the board has defined in that section, Wetterling offenses. And basically what the board has done, Your Honor, is I can inform you.
Yeah, Wetterling offenses, crimes defined as sex offenses pursuant to the Jacob Wetterling Crimes Act.
Correct. And that is, looking at that, I can tell you that is based on, I'm sorry.
Okay, so sex offenses are not defined under the Wetterling Act unless you can demonstrate to me otherwise.
Well, I think it's, I know I go, in my brief, I cite to several sections in the Wetterling Act where the board indicates that there are certain definitions that are made in terms of what are the particular offenses that.
All right, but the bottom line is, by regulation, you say these are Wetterling offenses for purposes of this statute and for purposes of these regulations.
Correct. And under the board's authority, under the statute to define what would constitute lifetime registration,
So
that's what we've done.
There has to be 2 of these acts, 2 of these Wetterling acts.
Correct.
All right. Now, another section, the same section of the statute, talks about or has been convicted of a sexually violent offense. So if you fall into one of those categories, you can't get out of registration.
Correct.
The next sentence says, the provision of this subsection shall also not apply to a sex offender convicted of a sexually violent offense, unless they've registered for 10 years.
Well, and I think the other part of that is, or a sex offense involving a child, which is a separate distinction.
Yes, or a sexually violent offense,
right,
which is exactly what you say above can never
right,
register.
and I think it is a little. There does seem to be a juxtaposition there. I think that the thrust of the language is, though, sexually violent offenders register for life. That overrides the sexually violent offender for 10 years. If you're convicted of a I think what that last sentence boils down to is sex offenders who are convicted of a sex offense involving a child, which these offenses also are, must register for at least 10 years.
All right.
Well, if there's
Thank you, Mr. Beck.
Thank you, Your Honors.